Under the topic Introduction to Law, in our first lesson we covered the definition and characteristics of law. Next, we looked at the purposes of law, then the reasons why people obey the law, and also the principles of just law. Today we are moving on to lesson number 5. In this lesson I am going to identify and explain in detail the divisions of law. In this lesson, we will look at the divisions of law in detail. And at the end of the lesson, I will give you popular exam questions relating to this lesson. So, law is divided into 4 main categories. The 4 main categories of law are international law, national law, substantive and procedural law, and public and private law. Those are the divisions of law. Having listed the divisions in which law is categorized, let me explain them now in detail. First and foremost, we will look at the international law. International law refers to the body of legal rules which is applied between states or nations. The rules are accepted between the countries as the law that will govern the activities the countries engage in with each other. The laws hence govern the relationship between the states, as the international law provides normative guidelines as well as methods and mechanisms to international parties. We should note that though international parties can be nations, organizations, or some individuals from different countries. At first, international law regulated relations between independent states, focusing mainly on diplomatic relations and war. But nowadays, international law has expanded. There are more subjects in international law. Hence, more parties involved in this international law we are talking about. Remember, we earlier mentioned that organizations and individuals are also parties governed by international law. So from our discussions so far, we have found out that law is divided somehow into 2 groups. That is the public law and the private law. Public law is concerned with the international relations between states. Legal rules governing relations between states is under public law. The International Court of Justice is one of the principal organs of United Nations. It settles disputes between states and gives adversary opinions. It is the world's court. So it is the one which influences the public international law and put it somehow into place. Private law, on the other hand, it has its own rules to private cases in international law. These include business law, labor law, civil laws between agents of different countries. The laws govern international relations between private persons. That is the difference between private law and public law. Let us now move on to the characteristics of international law. In international law, its principal participants are equal sovereign states. Participants are states or nations who govern themselves fully, govern their resources, and have their own laws. Secondly, international law is not forced on states. Nations are not forced to comply with all international laws. International law gives guidelines on what is commonly expected from various nations. Police or any other authority is not available to enforce or impose those laws on the states. So thirdly, there is no legislature in the international law. There isn't a central law-making body in international law who review, analyze, and make new laws. No one manages the creation of laws in international law. And the last characteristic is international law is not obligatory at all, but sanctions can be used to influence an offending state to comply with the international laws. The sanctions can be economic or diplomatic. These sanctions will motivate the offending state to comply with the international laws. Having fully comprehended what international law is, let us look at the benefits, functions, or importance of international law. Firstly, international law allows for the practice of stable, consistent, and organized international relations. These rules provide order among nations. Without international law, there could be chaos. International law sets up a framework that defines states' legal responsibilities in their conduct with each other. Its domain encompasses human rights, international crimes, refugees, migration, problems of nationality, treatment of prisoners, use of force, conduct of war, and world trade. Finally, international law somehow provides order in all these given examples. Otherwise, things were not going to be okay among all the nations. Now, the drawbacks or limitations of international law. International law lacks some form of international government. It lacks effective machinery or authority to enforce its rules. There's no international police to help implement its law. Additionally, international law cannot interfere in the matters within domestic jurisdiction of the states. For example, human rights are routinely violated in many nations. At this moment, let me go into the sources of international law. The main sources of international laws are customs and treaties. Judicial decisions are additionally a good source of international law, as it is used as a reference for international laws. Firstly, customs. Customary law is developed out of a practice by states of adhering to a particular custom out of the sense of obligation. Customary international law is therefore made up of rules that are derived from a general practice which is accepted as law. Therefore, international customs are habitual ways of behavior followed by those concerned states. These customs are habitually observed by the parties involved in international relations in some way. The customs are followed until they become an obligation to obey them, and legal consequences may be attached on those who do not follow them. For instance, prohibition on torture and also granting of immunity for visiting heads of states. Treaties, on the other hand, are written agreements that states willingly sign and ratify, and as such are obliged to follow. Such agreements made through treaties govern the mutual relations between states involved. The treaties, however, are only binding on those states that have signed those particular treaties. Thus, treaties only apply to states which have agreed to its terms. The treaties are valued and based on the fact that they should always be kept, honored, and adhered to. Treaties can be bilateral, that is between two states, or multilateral, which is among several states. If a nation no longer wants to be bound by the treaties, that nation can opt out. The examples I have for you: African Union. African Union was signed by 55 members. It is concerned with the international relations, political, economic, and social-cultural areas of those nations involved, including eradicating preventable diseases and promoting good health on the continent. The other example is SADC. SADC is another good example, which has 16 Southern African countries members. It furthers also socio-economic cooperation and integration of countries involved. Now let us look at the last major source of international law, which is judicial decisions. The International Court of Justice judgments have influenced greatly international law. References are made to past cases. The previous decisions are examined in order to solve conflicts between nations. The International Court of Justice judgments have influenced greatly international law. The past International Court of Justice and advisory opinions are referred to as a means of maintaining uniformity, equality, and continuity in the international law. Our example, as I have been saying, is the International Court of Justice, which is used as a reference point. The past cases are used to determine and give opinions and advice in future cases. From all we have covered in this section, I think we have all already deduce the examples of international law. Let me just mention a few while we are winding up this section. Number 1, international commercial laws, like tax laws and other modes of transport. International criminal law, which includes war crimes, drug trafficking, and crimes against humanity. Number 3, the international human rights law. Right to life, right to fair trial, right to privacy, freedom of opinion, freedom of belief and religion, the list goes on. And lastly, number 4, the international refugees law.